Hi, I'm Chris Newman and I want to talk to you about cultural literacy applied to the Treaty of Waitangi, which is New Zealand's historic document from 1840. And I'm going to use the whiteboard to make the points. So the Treaty of Waitangi, what it is and what it is not. And we're going to look at this from the viewpoint of logic, rhetoric and grammar. We're going to be logical about this. We're going to deal with facts. And we're going to be rhetorical. We're going to make it convincing. And of course our grammar is going to make sense. So what is it? Is it a contract? Well, let's check our law dictionary for contract. And we find out the Treaty of Waitangi is not a contract, because in a contract there needs to be an exchange of money, or something like money. There must be what they call consideration in a contract, and that's what this little legal dictionary says. And therefore the parties must have an intention to create legal relations. Neither of those conditions existed, so it's not a contract. There is no contract in the treaty. It is an agreement. So it's an agreement, not a legally binding contract. Now, next part, who is involved in this contract or this agreement? Because it can't be a contract because there's no money exchanged. There was no legal formula and people weren't signing like you do for a deed of a house or a business where you sign a contract and you're exchanging money. None of that existed in this agreement. It is between three parties. The three parties involved are mentioned quite clearly. There's Queen Victoria, and then there's, I'm just going to say Queen Vic, there's the chiefs and tribes, and there's the people of New Zealand. People of New Zealand. And so this is clearly set out. So it is not a partnership between Crown and Maori. It's not a partnership, and there's no partnership. There is no mention of partnership anywhere in the text. Not a partnership, and there's not a Crown Maori relationship set up, because it's got three parties. And remember, the Queen is Queen Victoria, not the corporation. So there is no corporation involved. What we have, these three parties are all people. People. And this is what is really critical to understand. There is, under the Interpretations Act in New Zealand, which was just to help us understand this, a people is a living, breathing human, one of us, that feels its existence. A person is a legal fiction that enters contract. This is information drawn from the New Zealand statutes. So we know that the treaty has got nothing to do with persons. There are no persons involved. They are people. So the living people here are entering an agreement, and it is about consent. Consent. Consent to do what? Consent to work together. So there is nothing binding. There's nothing binding in this thing. All of this is what the New Zealand government, the Maori Council and the treatyist industry are involved in. These things. They think there's a contract, they think there's a partnership, they think Crown and Maori are involved in some contract or relationship, and there are corporations involved, and there's persons, which is a legal fiction. I'll just explain that to you. A person is called a juror. I'll get the correct language. A juristic person is an artificial person, such as a corporation, and it's subject to legal rights and duties. That is contrasted to a people. So that none of this is in the Treaty of Waitangi. I've just used logic to show you. Whereas the use of rhetoric is just words to make a big spray, creates all these things out of nothing. When we go to 1840, what happened? This document was drawn up by, not by lawyers, by, we'll call them church ministers. Church minister and Lieutenant Hobson, representing the Queen. There were no lawyers. There were no lawyers, so lawyers have got nothing to do with the Treaty of Waitangi, nor was there any government in New Zealand at that time. There was no government. So this has got nothing to do with government's past statute. So I'm going to put it up here. Statute, and government. None of that existed here in New Zealand in 1840. There was nothing of the sort. So, in essence, the treaty is an agreement between three parties to consent to what? To becoming subjects of the Queen. Now that's all about rights. They was consenting to accept the rights of being British subjects, which has got nothing to do with any of this stuff over here, which is all commercial law. There was no jurisdiction in New Zealand, there was no government established, there was no statutes, no lawyers, no politicians, none of that stuff. It's entirely about people. What I've given you is a simple logical analysis that crashes completely the treatyist argument, which is what this whole case here is the treatyist argument is entirely rhetoric. This is what you will hear from the Maori King, from all the academics, from the members of Parliament, from the Waitangi Tribunal, from all of these talking heads in the media. None of them are applying the logic and the truth to the case of the Treaty of Waitangi in 1840. This is what it is, and this is what it is not. New Zealand is totally engaged in a discussion about what is not as if it were real, while nobody is looking at what is actually true and what needs to be discussed. In the next presentation, I will go into the principles of the treaty and explain how that all works. But before we do that, I'm going to do a brief commercial. This information is available in my book, Fraud, Plunder, Treason and Our Treaty, which is available at newmanpress.com. The facts, the background, the logic is all clearly set out and you can order it online. But this little presentation gives you a good understanding of the very basis for having an intelligent, logical and truthful discussion that in fact is an agreement with the Queen Victoria, the chiefs and tribes and all the people of New Zealand. Thank you, I'm Chris Newman and this is an introduction to what is the Treaty of Waitangi and what it ain't. Thank you.